Welcome to the Digital Planning Podcast. This series is designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. To keep up with all things digital, please subscribe to iTunes, Stitcher, Google Play, or wherever you download your podcasts. And now, Jennifer Ziegel, a partner at Kleinberg LLC, Ross Bruck, a principal of Estate Genie, and Justin Brown, a partner at Troutman Pepperell Hamilton Sanders LLP, with today's topic.
Welcome back to the Digital Planning Podcast. I am Ross Bruck. I'm joined as always by my co-hosts Jennifer Ziegel and Justin Brown. Today we're going to dive into the world of privacy, and in particular the California Consumer Privacy Act. We've touched upon privacy issues before. If you haven't already listened to it, please go back and listen to our interview with Lisa Garber. But to help us decode the CCPA, with us today is an attorney with the law firm Saul Ewing, Arnstein & Lair, Patrick Hromisin. He focuses practice, among other things, on privacy and cybersecurity. And in full disclosure, Saul Ewing was my prior employer, and that's obviously how Pat and I know each other. So, Pat, welcome to the podcast.
Hey, thanks for having me on.
Before we dive into the specifics of the CCPA, can you give us a little background on how you came to focus at least part of your practice on privacy issues?
Yeah, I'm a litigator, and I started in litigation, concentrating on government investigations and complex litigation, some of which involved some pretty funky electronic discovery issues and technical issues. So I got involved in technology and government enforcement early in the game, and that sort of segued into an interest in data privacy and cybersecurity. And I'll admit, when I got started in it, I thought I was going to be doing a lot of breach response, because in the government enforcement space, I was doing a lot of internal investigations, and a lot of breach response requires that sort of thing. But as I started working in it, we got a lot of questions from clients prospectively about, how to plan and how to be compliant with various privacy regulations that were both in place already and coming into place. So the practice just grew from there, just being responsive to what clients needed. And I do, far more prospective counseling now than, I would have expected when I at the very start. But I really enjoy that type of work. So it's good to have, kind of a foot on both sides of it.
Great. So let's talk California Consumer Privacy Act, CCPA. Can you give us the 30,000 foot overview, just a general introduction into what's involved here?
Yeah, sure. It might be helpful to understand, and I think a lot of people know what the GDPR is, which is the European Union data privacy regulation that came into effect back in 2018. The CCPA has some parallels to that, but they're often discussed in conjunction with each other. So I'll reference the GDPR a couple times because it helps to explain what the CCPA is. The CCPA is a statute that's on the books in California. It took effect on January 1st of this year, and it started being enforced as of July 1st by the California Attorney General. One of the main things that the CCPA does differently from most data privacy laws on the books in the United States is that it applies broadly to data across several different categories and many different industries to many different types of businesses. And that's a change for the United States, because the United States has generally taken what they call a sectoral approach, where there are different frameworks that apply to specific categories of data. One of them that almost everybody's familiar with is HIPAA. HIPAA applies to health data, and it only applies to certain covered entities. Another one is FERPA for educational data and educational institutions. But that has generally been the approach that has been in place for US privacy law. And one of the big contrasting approaches to that is something like what the European Union GDPR does, which is it applies to personal data virtually no matter what kind of entity is processing it, no matter what kind of entity it relates to. So it's a very, very broad-based approach. And CCPA doesn't quite go as far as GDPR, but it does apply a little bit more broadly than the sectoral frameworks that have generally applied in the US. So that's one of the big things that's innovative about it, and that's different. Its scope is a little bit more broad. And to give you the really high level of what it does, it puts a few more restrictions on businesses that want to share and collect people's personal data. And it also gives consumers some more rights with regard to the businesses that are collecting and processing their personal data. Consumers have the right to opt out of companies selling their personal data to other companies. And consumers have the right to go to companies and ask for example, copies of their data or categories of data that have been collected. And generally speaking, companies have a greater obligation to provide notice to consumers about what data is being collected and what's being shared. So that's the really broad view of what the CCPA does.
Pat, what entities are covered by CCPA?
The CCPA applies, first of all, it only applies to for-profit entities. The term that the CCPA uses is businesses. So if you fall within the definition of a business under the CCPA, then you're covered. And to fall within the definition of a business under CCPA, first of all, you have to be doing business in California, even if you're not located in California. And there are three threshold requirements. The first of which, if you meet any one of them, you qualify as a business under CCPA. So the first one is having an annual gross revenue over $25 million. The second one is selling or sharing for commercial purposes information of 50,000 or more California residents, households, or devices. And the last threshold is deriving 50% or more of your annual revenue from selling the personal information of California residents.
So those requirements already sound very specific, like it's not going to touch on a lot of businesses, it's not going to touch on a lot of consumers directly. Why should I care about the implementation of the CCPA if it's such a broad, and maybe it only impacts such a small segment of the tech world, or of any business, I should say?
Yeah, there are a couple of reasons, and you're right. It's not going to apply like the GDPR did to every mom and pop operation that's processing personal data. I mean, obviously those thresholds are a little bit high, and there's a series of amendments that are on the ballot for this coming November for CCPA, and one of the changes, if this ballot measure gets approved, is that the threshold of 50,000 households or consumers or devices is going to go up to 100,000. So the threshold is going to get even a little bit higher. So, if you're way, way underneath it, if you have no chance of hitting $25 million in revenue, and you know for sure that you're not processing the information of 50,000 or more California residents, in some ways you can kind of breathe easy and know that CCPA is not going to be a direct concern for you. But CCPA comes into the picture for a lot of smaller enterprises because the bigger businesses that are subject to CCPA face some compliance obligations with regard to companies with which they share data. Even if they're not sharing it even if they're not selling the data, even if they're not sharing it for marketing purposes or what have you, if these companies that are subject to CCPA have a business relationship with a small company that itself is not subject to CCPA, the CCPA regulated company has to put some contractual provisions in place to make sure it's complying with CCPA and that it's providing the data to its service providers in a way that complies with CCPA. So that is how it comes onto the radar for a lot of smaller enterprises that themselves aren't going to meet those thresholds.
So you just mentioned that there is a question on the ballot in November in California addressing maybe some of the tighter restrictions of the CCPA. I think the backstory there is interesting. Can you talk a little bit about how CCPA came about and how that led eventually, how the implementation there, or perhaps in some eyes, the lack thereof, led to the initiative to put this question on the ballot come November?
Yeah, it actually is. It's pretty interesting. It's a story. You can look at it a few different ways. If you want to take a positive look, you can look at it as consumer sentiment really getting noticed by the legislature, and the government responding to people's concerns. But the short version of how it came about is there's a real estate developer, pretty wealthy guy in California named Alistair McTaggart, and he apparently had a chance conversation with somebody who worked for a big tech company, and they got talking about the company's approach to personal data. And it's no secret that over the past years, personal data has become a more valuable commodity for companies. You can use it in a lot of different ways. And especially with big data processing and machine learning and artificial intelligence analysis, there's a lot you can do if you have a lot of customers' data. So he got talking about this with somebody who was working in that space and was himself shocked to find out what these companies were doing with their users' personal data. And he was further shocked to find out that what they were doing was not really regulated to a great degree or with any specificity at all. So he, took that concern, he formed a nonprofit, and the direction they chose to go in was to draft a ballot initiative to get a law on the books, which ultimately became CCPA. As I mentioned earlier, the key provisions are to allow people to opt out of the sharing of their data and give them greater transparency and some additional rights with regard to the companies that have their data. So that's where they started from. And there was a deadline in the middle of the summer of 2018 where it was the drop dead date for McTaggart's proposal to get on the ballot. And the California legislature and California commerce groups and even nationwide commerce groups like the Chamber of Commerce and whatnot started to get a little concerned that they weren't sure that McTaggart's proposal was thought through well enough. They thought it might be a little too restrictive. So they started, and the legislature was responsive to those concerns, and McTaggart was willing to work with the legislature. So what happened was the legislature, kind of to forestall the CCPA ending up on the ballot, it drafted its own version of CCPA, and it got passed. And it was a pretty quick effort by the legislature. And if you really dive deeply into the terms of the CCPA, there are some ambiguities and some inconsistencies that are, I would say, a remnant of the speed with which it was drafted and passed. But so, long story short, it was passed as a way to keep the original version McTaggart came up with off the ballot. But McTaggart, he was willing to go along with that. He didn't go kicking and screaming, but in the end, he was a little concerned that what ended up on the books was not as strong as what he had hoped for. And he was also concerned that later, legislatures could essentially gut it. So he, shortly after it did go on the books, he started working again towards another ballot initiative. And this time he didn't allow the legislature to forestall it with its own legislative fix. So the ballot initiative that's going to be on the ballot this November is what's known as the CPRA, which is the follow-up to the CCPA. Some people call it CCPA 2.0. But what it does, it amends the text of the CCPA in a few different ways. Broadly speaking, it creates a more structured way for the CCPA to be enforced. It creates greater restrictions on the legislature if it ever wants to amend CCPA in the future. And it imposes a few tighter restrictions than the CCPA itself imposes on businesses that want to share personal data with other businesses.
Patrick, what are the consequences if companies violate the CCPA that are subject to it?
Well, the Attorney General has enforcement powers. So, like I mentioned, there was the timing set up in the law itself was that it went into effect on January 1st, and the Attorney General started enforcing it, started having the ability to enforce it on July 1st. And the reports that came out were that the Attorney General, there's a 30-day cure period. So the Attorney General essentially has to put an alleged violator on notice. And then the alleged violator gets a 30-day period to cure the deficiencies that the Attorney General has recommended. And the Attorney General reported that it sent out, I believe it was unspecified, but an unspecified number of deficiency letters in early July. They didn't release names of which companies that they were targeting, but we're now past the 30-day window for those, and we still haven't seen any official enforcement proceedings yet. But there are statutory penalties. There's a certain, depending on the scope and nature of the violation, there's a specified amount, kind of like under the False Claims Act, there's a specified amount of statutory penalty per violation that the Attorney General can enforce. So that's the most direct consequence. But there's also, the CCPA does also create a private right of action for certain instances. The way most people read the CCPA's description of the private right of action it creates is that it seems to be targeted at a breach, an intrusion. But the terms it uses is unauthorized disclosure of certain personal information. And there have already been a number of private lawsuits in California where plaintiffs are alleging that some companies have either shared their data improperly with other companies or failed to secure their data adequately. And those plaintiffs are invoking the CCPA. And one of the big things that's notable about the private right of action that the CCPA creates is that it specifies statutory damages. Because a lot of times in situations where a company has either admitted to or allegedly shared information outside the scope of what it has given customers notice of, a lot of times one of the challenges plaintiffs face is proving what the damages are. If I give my information to a social media company and then that social media company shares it with some marketing company and they never told me about it and I never agreed, how am I really damaged? How do I quantify that? Well, the CCPA gets around that question by saying, here are your damages. We specify that there are statutory damages. So that's why it does, to the extent that someone does meet the requirements for the private right of action under the CCPA, it does make it a little bit easier for private actions to proceed.
So, Pat, many of our listeners have probably heard of GDPR, but may not have heard about CCPA. Can you talk a little bit about the similarities or differences between GDPR and CCPA?
Yeah, one thing to know is that if you are familiar with GDPR, the CCPA is significantly more limited in its scope. The biggest restriction, the two biggest restrictions that I think the CCPA imposes are the obligation to provide more comprehensive notices to consumers and the obligation to respect consumers' opt-out requirements that would prevent a company from sharing or selling personal information. The GDPR contains a number of greater requirements. Most notably, I would say, is the essentially the default prohibition on transferring data out of the European Union unless there's an adequate degree of protection for the data. That has created a lot of obligations for companies all over the world because essentially to get data out of the EU, you need to comply with the GDPR. And California doesn't have mechanisms like that. It's not quite as restrictive. But the similarities are that they do purport to apply to data across a broad range of categories and a broad range of businesses, again, in contrast to the US's normal sectoral approach. But even having said that, one thing to note about CCPA is the CCPA creates carve-outs. For example, if a covered entity under HIPAA is processing data and the data is covered by HIPAA, then the CCPA explicitly says, all right, we're out. The CCPA is not going to apply to that data. And there's a similar carve-out for the Gramm-Leach-Bliley Act for financial institutions and a couple other carve-outs as well. So the CCPA is significantly more limited in scope than GDPR, but it does represent the US's most significant attempt to put in place some of the principles that underlie the GDPR.
Quick question out of ignorance on the GDPR. Is that the reason why whenever I go to a new website, I'm seeing that I have to accept cookies now and that the default, that I have no choice but either to leave that website or accept the data privacy policy of that website, or am I misunderstanding?
That the answer to that question is probably yes, but in an indirect way. So yeah, the relationship between the GDPR and cookies and worldwide users who are not located in the EU is pretty interesting. And I mean, the GDPR went into effect on May 25th, 2018. And I mean, I remember websites were popping up notifications like crazy. They were all changing their privacy notices, and they were all a lot of them were changing their approach to cookies as well. And I mean, those of us who were working in that space had a really busy time around that time as well because we were helping companies do that. But to try to explain why the European Union GDPR results in you having to click on cookie acceptance is a little convoluted, but the shortest way I can say it is that there was a pre-existing law on the books in the EU called the e-privacy directive. And the e-privacy directive requires consent for cookies, among other things. So in order to comply with e-privacy, this old law, companies in the EU had to get consent. And one of the big changes that GDPR put in place was it changed the definition of consent to mean affirmative informed consent. So before GDPR, you could put up one of those windows that just says, hey, we use cookies. The box was already checked. You know, if you use this website, you're accepting the cookies, or a pre-checked box in an agreement that just says, I agree, let me get through to the website. Once the GDPR went into effect, those types of consent were no longer considered valid under GDPR. So then in order to comply with the older law, the companies had to change their approach to consent and get affirmative consent for the use of cookies. And now still, why do those of us in the United States have to deal with this? The answer to that is because in a lot of situations, it's not really practical, or it's just not worth the effort to differentiate between users in the EU and nations worldwide. And that, whether you're talking about GDPR or CCPA, or there's a new Brazilian privacy law that has a lot of echoes of the GDPR, and there are a few others worldwide, one of the key decision points for anybody subject to it is, are you going to treat the people who are covered by GDPR one way and the rest of the world another? Or are you just going to treat everybody in the world as though they're subject to GDPR? So a number of companies, when GDPR went into effect, said, you know, look, we're just going to have to treat everybody in compliance with GDPR, because trying to differentiate between users in the US and users not in the US would just be too impractical. And that's, you know, certain US companies, the GDPR doesn't apply to a US company if the US company isn't, you know, for example, marketing towards the European Union or trying to do business in the European Union. And there was some concern around the time it came out that, you know, just if EU users are coming to my website, does that mean I'm subject to the GDPR now? And you know, it's not quite that expansive. It's not quite that crazy. But there was some discussion I recall about people trying to put up, you know, IP address screeners to prevent people from the EU, you know, getting past the initial parts of their websites because they just didn't want to have even the chance of being subject to GDPR. And then I even remember some people discussing, you know, what if a person in the EU is using a VPN and spoofing their IP address? And I mean, my answer at that time was, I don't think the EU regulators are going to go out of their way to find, you know, a US company that's dealing with the European Union person who's going through a VPN and make an example out of them. But that is one of the key decision points, and it's because of, you know, the difficulty of distinguishing between users in one location of the world and another, that those of us who aren't in the European Union started to see these changes come about with the GDPR. And there's an element to the GDPR also that's, I mean, it reflects judgment on the part of the European Union that privacy in your own data is a fundamental human right. And there is, I think a lot of people would agree with this, there's an aspirational element to it. They wanted to give people greater rights and make it harder to use people's data without giving them transparency and giving them some element of control. And one of the ways they do that is by the GDPR's extraterritorial application and its restrictions on transfer of data out of the EU to other countries. The European Union is basically saying, we've made this decision. We think this is really a fundamental human right, especially with the advances in technology that have been taking place. And, we're regulating within our own borders, but we're going to do everything we can to try to get anybody, we come into contact with to follow the same principles as well.
So Patrick, as a follow-up to that, what are you seeing coming out of the legislatures for various states in terms of privacy policies or proposed legislation?
There are a few initiatives that they seem to kind of come in fits and starts. Washington State really seemed like it was moving towards a more comprehensive data privacy package, and that has really gotten, I don't know if I would say sidetracked or whether it's officially dead, but it's not going to be on the books anytime soon as of now. Nevada, for instance, has an opt-out mechanism that's similar to CCPA, but not some of the other broader requirements of CCPA. In Illinois, there's a law that predates CCPA by a while, called the Biometric Information Privacy Act, and that governs companies' use of individuals' biometric data. And so far, Illinois is the only state that has a law like that on the books. But those are just a few examples. There has been talk for years about whether and when there is going to be a comprehensive federal data privacy law. And one of the reasons that really bubbled up was before CCPA went into effect, a lot of people were complaining with good reason that CCPA was just going to contribute further to the kind of patchwork or crazy quilt of different privacy laws that companies in the US have to deal with. And the notion was that wouldn't it be great if the federal government could put a law in place that would preempt CCPA and preempt any other state that was going to try to do some variation on CCPA. And, at least then we'd have uniformity. There would only have to be one law we'd have to deal with. And needless to say, here we are, CCPA is on the books, and CCPA, there's a very good chance it's going to be amended due to the ballot initiative in November. And we are nowhere near a broad federal data privacy regulation. But that's the idea. I think a lot of people would prefer to have a broad system in place. That's one of the things about the GDPR. It's a blessing and it's a curse. The GDPR is pretty restrictive and it applies really broadly, whether you're, a pizza place on a corner or whether you're a giant multinational company. But at least with the GDPR, there's just one rule book, and the regulators can issue guidance under the GDPR, and you can kind of take it for, take it that's going to apply to in a lot of different situations. But here in the U.S., we don't have anything like that degree of uniformity. So, there are a lot of companies in the U.S. that have concerns with GDPR and CCPA and HIPAA and BIPA, the Illinois Act, and they have to be up to speed on all of them in order to comply with them all. So, there's a significant amount of interest in having a federal law that would streamline that a little bit more. But we're nowhere near it. I would have said, maybe this was naive of me, but in maybe early 2018, there were, leaders of big companies calling for a GDPR-like law. And there were, even maybe as late as 2019, there was a lot of interest in action on that front. And it really seems to have sputtered, I would say, probably due to the inability to compromise in Congress at this point. But that I do think something like that is going to happen at some point in the future. And if it doesn't, there are going to be more and more states that are going to put laws on the books that either go as far as CCPA or regulate a little differently from CCPA. And the patchwork effect is only going to get more noticeable.
Pat, to build off of that idea, the Uniform Law Commission is a body that we've discussed before with other acts. For example, RUFADA has come into play, and that was driven by the ULC's initiatives. And I believe that they have a drafting committee called the Collection and Use of Personally Identifiable Data Act, which started meeting earlier this year in 2020, and it has a goal of drafting uniform legislation sometime in 2021 to hopefully have adopted across multiple states. But putting that aside for a moment, if that doesn't happen, or until it happens, as you just discussed, we're going to see a hodgepodge of different states having more and less stringent standards when it comes to privacy and their own individual acts. But similar to the way in which consumers outside of the EU still have to be cognizant of the GDPR, are we going to have a system where, because of the interstate commerce and the nexus between states, we all just have to defer to whatever state has the most stringent standards and have to be aware of, if California's the most stringent privacy rules in the books, that every business should be cognizant of that above all else, because of the likelihood that you're going to have commerce from consumers in multiple states?
Yeah, I mean, I think the short answer is probably yes, to the extent that states are, I mean, even if there is a uniform law proposed, states aren't necessarily going to have to adopt it. Even if there's widespread adoption, we might see greater predictability, but there would be nothing to stop any one state from putting a more restrictive measure in place. And if that state happens to be North Dakota, there's probably not going to be a huge rush to, make sure you're in compliance with it. But when that state happens to be California, or if it should happen to be New York or Texas or Florida, it gets pretty quickly to that decision point, that fork in the road, where you have to decide, am I going to try to treat residents of that state one way and everybody else another way, or am I going to try to treat everybody the same way? And again, with CCPA, just by the way it's written and the things it puts in place, it's not quite the same as it was for GDPR. The way that plays out under CCPA is mostly with notices. It's easier to just give everybody the same notice you're required to give everybody under CCPA. But the CCPA, one of the big components of it is requests from consumers. And if the consumer is not in California, you can tell them to take a hike. That's pretty easy. That's not a really hard fork in the road. But to the extent that there are restrictions on things like notices and collection and things like that, then it becomes a more difficult decision point.
Pat, how does CCPA affect attorneys and law firms and their clients? So I am a trust and estates attorney, so I may have clients out in California, even though I'm physically located in a state other than California. Does that impact me? Does the fact that my firm has an office in California change the way that my firm or I are impacted by CCPA?
Yeah, I mean, the short answer is that I discussed earlier that CCPA does create some carve-outs, for instance, for HIPAA and for GLBA data. It does not carve out law firms. So law firms can be subject to CCPA. So, I mean, that's kind of the first headline. The second one, though, is that in order to be directly subject to the CCPA, you have to meet the threshold. So, if you're under $25 million in revenue and not sharing or selling 50,000 California residents' personal data, then, you're not probably going to be subject directly to CCPA. Now, if you work for a big firm and you do meet those thresholds, you do need to take a much closer look at what your obligations may be. But even if you're a smaller firm or a solo practitioner, to the extent that you're doing work for or with companies in California that are subject to the CCPA, or nationwide companies that are subject to the CCPA, that notion that I mentioned earlier of service providers is going to probably come into play, because companies that are subject to the CCPA need to put restrictions in place on their sharing of data with their own service providers to make sure that their sharing of that data complies with the CCPA. So whether it's law firms or other small companies, I mean, in the past couple of years, tons of companies have received these, proposed amendments to, a contract, a service contract, or I guess for a law firm, it would be an engagement letter, containing some new restrictions on what the service provider can do with the data. So that's one way that even a small provider would be likely to come across the CCPA and have it pop up on their radar. Another thing to note, though, is that the CCPA, while it doesn't contain an explicit carve out for law firms, it does say that, that there's a provision that says something to the effect that nothing in this law is going to prevent you from exercising or defending against a legal claim. So in a lot of ways, you can't be hindered in your representation of a client by your duty to comply with the CCPA. So the CCPA did acknowledge that notion.
Pat, we're all aware of hacking and intrusion. And I'm just wondering, do these privacy laws do anything to prevent those hacks and to safeguard individuals?
In a way, yes. And this goes back to one of the bigger things, which is that when people think about this general topic and think about this general space, hacking is one of the things that comes to people's minds a lot. And cybersecurity is one of the things that comes to people's minds a lot. But privacy as a broad field is bigger than just cybersecurity. Security is a component of privacy. And an individual can't truly have privacy and control over his or her data unless the entities with which he or she is sharing it do practice good cybersecurity. But cybersecurity is sort of a subset of the broader scope of privacy. And the way that both the GDPR and CCPA deal with security as a subset of privacy is that they both include a generalized requirement that companies or entities that are processing personal data put in place reasonable security measures to ensure that that data is not going to be subject to breach. But neither of them puts detailed technical requirements in place. Neither of them specifies even, by reference, another cybersecurity framework like the NIST framework in the United States or anything like that. They just create this broad standard of reasonable security. And that's one of those things that as these laws get older and there are more enforcement proceedings and more litigation, there's going to be more meat on the bone in terms of what reasonable security means. But I think the drafters of both of these frameworks realized that they didn't want to wed themselves to a particular approach right now and have that approach become obsolete due to the progression of technology. So the upside is flexibility, but the downside is that it's not entirely clear what reasonable means. One thing, and this is not legal advice for your listeners, but one thing that's a reasonable approach is when you're trying to say, when you're doing your own assessment of whether you're in compliance, look at there are existing frameworks. Like I mentioned, NIST is one of them. It's the National Institute of Standards and Technology. They promulgate certain cybersecurity frameworks. And ISO certifications are another one. But if you have, for other reasons, chosen to adopt one of those security approaches, then, as long as you're in compliance with that approach, it seems like you have a pretty good argument that you're taking reasonable industry standard security measures with regard to any personal data you're processing. But again, the laws themselves don't say, if you comply with this framework, you're in a safe harbor. The laws just don't go that far.
Pat, it's been really great chatting with you today. Jen, Justin, anything else that we should cover, that we should ask?
One final thought, and thank you, Patrick, so much for coming on and being a part of the Digital Planning Podcast today. In the vein of planning, Are there any rights that an agent under a power of attorney would have in terms of opting out of any policies or provisions or disclosures or data disclosures under the CCPA for a person that they may represent under the power of attorney?
Yeah, the CCPA does include provisions that specifically enable an agent of a California consumer to exercise the consumer's rights under the CCPA. And that actually, I mean, not to go down a whole rabbit hole, but it one of the challenges that it creates for companies that are subject to the CCPA is when they get a request purportedly from a California consumer, they have to verify that it's truly the consumer who's making the request. And when the request comes in via an agent, there's another layer of verification that's required. The company needs to know not just that the consumer is a real person and the agent is a real person, but the company that's going to be responding to the request then has to confirm that the agent is indeed authorized to act on behalf of the consumer. So it does add another layer for responding to inquiries that come in that way. But yeah, the law does make it possible for agents to act on behalf of consumers.
So in connection with that additional layer of security, are the time requirements for responses by companies to these types of requests under the CCPA elongated in that situation?
If it's just, no, there's not a specific elongation if it's just a personal representative that's making the request. But, that's maybe something that would be considered down the road. This is the first year that companies have had to respond to them. But again, to look back at the GDPR, companies that were subject to the GDPR had to put a system in place for responding to requests from EU, people located in the EU under the GDPR. So there are a lot of parallels between that and CCPA. So for a lot of entities, that was a pretty similar exercise. But so there was a well-developed, at least for a lot of companies, there was a well-developed system for responding to them. So it hasn't been quite as much of a burden as it was when GDPR first went into effect. But for companies that are subject to CCPA and not GDPR, maybe added timeframes, adjustments to the timeframes, that might be something they want to propose or consider, as time goes on.
Well, Pat, thanks so much for joining us today and for teaching us all about the California Consumer Privacy Act. For all of us here at the Digital Planning Podcast, thanks for listening, and we'll talk to you guys later.
Thank you for listening to this episode of the Digital Planning Podcast, the podcast designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. Please subscribe to this podcast and leave us a rating or review on iTunes, Stitcher, Google Play, or wherever you download your podcasts. Thanks for joining us. We'll see you next time.
This podcast is not intended nor should be relied upon as legal advice, nor is it creating any attorney-client relationship with a listener and the hosts or guests. The information provided is only for educational and informational purposes, and the information provided will likely change.